Right, good afternoon. Hello, everyone. Welcome to our webinar this afternoon. I'm really pleased that you've been able to join us today. And for those of you who have attended our last two webinars in our series, welcome back. If we haven't met before, I'm Stephanie McCleery. I lead our HR recruitment practice across the Northern Home Counties. Frazer Jones also has teams across the rest of the UK, Ireland, and internationally. And if you happen to be looking for work currently or looking to hire into your organisation at the moment and would like to discuss how I can support you, please do drop me a note and we can schedule in some time in the coming days. So today is all about key UK employment law changes in 2024. And I am very excited to be joined once again by our wonderful guest speaker, Emma O'Connor. Emma is Legal Director and Head of HR Training at Boyce Turner. In this session, Emma will be taking you through a number of topics that will have an impact on you as HR leaders this year. If you do have any questions throughout the webinar, please do add them to the Q&A. And if we have the time, we will certainly answer them at the end of the session. And if we don't, then we will put together a fact sheet and share them with you in the following days as we've done previously. So without further ado, I will hand you over to Emma.
Thank you very much, Steph. And hello, everyone. Well, thank you so much for joining us. As Steph said, this is our third webinar now, which is amazing. And it's fantastic to have your support. So thank you very much for that. Steph said, I'm Emma O'Connor. I'm a legal director in the employment team at Boyce Turner, and we support clients both with employment law, property, disputes, litigation, corporate work, both in the UK, in Europe and globally. So if we can help at all with any of your employment related questions, manager training, HR updates and awareness, or any corporate or litigation matters, then please do get in touch. So I actually have some law to talk to you about today. Goodness me, the amount of times I've been struggling to write updates and quarterly reviews because we've had very, very little law to talk about. But we have a bumper set of changes that are coming up, particularly in April. So we need to be aware of what those are and obviously what that means for you, either as an HR professional or a business manager. So how are those changes going to affect your policies, your contracts, your processes, and also your employee related issues? What I will say is today is an overview. There is a lot happening. There is a lot of detail in some of the changes. But what I'm going to give you is some HR heads up, some themes to be thinking about now, some ways in which you can support your managers strategically, and some of the changes that you need to make. So as ever, if you have any specific questions or queries, then as Steph said, please do get in touch because we are here to help and support. So what I'm going to do is I'm going to sort of take you through month by month, and I'm actually going to start back in January because as we woke up on the 1st of January, there were some changes that happened, and actually some really important changes. And primarily to holiday and holiday pay calculations, holiday carryover, and the way that employers manage holiday for not just their employees, but of course, remember that that's statutory right to take holiday enshrined within the working time regulations, remembering that that is a right not just for employees, but for that wider category of workers as well. So remembering we've got that wider category there to think about. Now, a lot of the changes that we saw to holiday and holiday pay aren't new. Now, what do I mean by that when we have new rules coming into effect? Well, as part of the transition and part of sort of the Brexit, when we left the EU, we were wanting to, the government were wanting to preserve the rights that workers had under EU law, particularly around EU case law. And so that when EU law and case law stopped being applicable, making sure that UK workers had those protections, what the government had to do was obviously assimilate those acquired laws, acquired rights into UK law. So a lot of what I'm going to talk about isn't new. We should have been doing this already because we've had European case law and domestic case law telling us that we should do. But for the first time, a lot of the rights have been enshrined within the actual UK law and UK legislation. So what's changing and what is what really now do we have set out? Well, I do want to, and it's very, very rare that I do this, but I do actually want to draw your attention to the new government guidance on holiday that was published on the 1st of January, because it is actually very good. So if you haven't had a chance to read it, then do have a look at it, and I can send around the link after the webinar as well, so you've got that. So do go away and have a look at it, because there are some useful information there, particularly around the different ways that people work. And a lot of the issues that we've seen around holiday and holiday pay have been because the law and what the law says about when holidays should be taken and how holiday pay should be calculated has not kept up with the way in which people are now working, particularly when we think about casual staff, irregular workers, part-year workers. So what we've seen is this sort of disconnect between what the law says and how people are working, and where we've had those case law is really to sort of bridge the gap between interpreting what the intention was around the legislation, remembering that holiday is a health and safety right, it's about well-being, it's about making sure people are taking adequate rest breaks, and then obviously between the reality about how people are working. So what is staying the same is that distinction in the legislation, and I know some of you will have different rights within your contracts, but essentially the basic holiday entitlement is staying the same. There is a 4-week basic EU holiday entitlement, and then in the UK we have an additional 1.6 days. And the reason for that is because some businesses would say employees could take 20 days including bank holidays, which actually meant that people only had sort of 12 days holiday, whereas the 28 days essentially that we have if you're a full-time worker covers off that 20 days worth of holiday plus the bank holidays. So that distinction is staying, and that distinction actually becomes quite important when we go on to talk about how we pay holiday. One of the rights that we've seen, and certainly the guidance picks up on this, is that there are now rights to carry over holiday. Not in all situations, but certainly there are specific situations in which employees and workers will be able to carry over holiday, carry over that entitlement. So we see that there is a right to carry over holiday. Again, it's not new. We knew this already. We've had European case law about it, but that right, if somebody is on long-term sick, to be able to carry over 20 days, that minimum basic holiday, again, that distinction is important. During periods of long-term sickness absence, again, 18 months after the end of the holiday year. We've got rights for individuals who are on family leave to be able to carry over 28 days holiday. So again, we've got to think about how that works in terms of, having conversations with people. How do you want to carry over your holiday? How are we going to sort of manage that? You're tagging it on at the beginning, tagging it on at the end. There's also going to be a right to carry over where the employer has not allowed an individual to take their holiday, and also rights to carry over where there has been some disagreement over the status of the worker. So they're going to be specific defined periods of holiday that can be carried over, time limits as to when holiday can be carried over and then it is essentially lost, and also those situations when holiday can be taken over. So what we need to do is we need to be looking at our holiday policies. What do they say about carryover? Yes, you can have things in your contract that allow workers to carry over a certain number of days, but there are going to be specific situations where employees and workers are going to be able to carry over more. So we need to be aware of those situations. Other changes as well are around record keeping. So employers now are only going to have to record compliance with the working time regulation to show that those key areas of practice are being performed. And again, there might be some employer specific requirements there for recording compliance with the working time regulation. So employers now are no longer going to have to keep those daily records of working hours. Again, you may wish to do so for sort of pay purposes, but it's about being able to demonstrate compliance with the working time regulation. So hopefully a bit of respite there for employers. One change that is coming in very quickly is with regards to that lockdown leave. So the holiday that was carried over because of the lockdowns, that holiday has to be taken now by the end of March. And if it's not taken, it's lost. So again, we need to be telling staff, auditing our holiday, who's got lockdown leave, have they taken it? If they haven't, then their window is reducing in which they can take it. Again, we can't pay in lieu for untaken leave except on termination. So again, there might be some things there that employers need to do to remind staff that they must be taking that leave, otherwise they will lose it, and that window, as I've said, is closing. So you've got until the 31st of March there to take that holiday. Calculating holiday pay, I think, has been, a headache for employers for a number of years. I mean, we've seen case after case on this. I think it was probably about 2017, you couldn't look at a legal update email without there being at least, 2 or 3 cases about what constitutes holiday pay and what employees should be paid when they are on holiday as opposed to when they are at work. And a lot of the cases that came through, and some of you will remember them, involving British Airways. There were cases involving, plumbers, lots of cases looking about British Gas was another sort of key case there, really looking at what employees are paid when they are on holiday, and is their pay and what they're getting as holiday pay, is that actually disincentivizing them from taking their leave? Because remember, holiday is about health and safety. We want to be encouraging people to take their leave. So we had lots of cases talking about, well, during holiday, an individual's holiday pay should reflect their normal remuneration. So not just basic pay, but actually what is it they are normally paid for being an employee, being a worker, and what that might look like. So we see lots of cases, and I'm sure you will remember that we're looking at things around overtime pay. British Gas and Lock was the classic one, looking at commission pay. And we saw this extension that during holiday, certainly there would be that looking at holiday pay as what is part and parcel of what the employee does, what is intrinsically linked to the employee working for you. What does their contract say, but also what in reality does somebody earn on a regular basis for working for you? And what we see now is this reflection of the case law now into UK law, which is saying that holiday pay, certainly for that basic holiday pay, that 4 weeks worth of basic EU pay, we really should be looking at normal remuneration. Now, for that additional holiday, that additional 1.6 weeks of leave, employers are able to pay basic pay. Now, many of you may already be paying normal remuneration. Some of you are going to go and have to look at what you're paying, particularly where you've got things around commission, where you've got overtime, where you've got those regular payments being paid to employees. Some of you may have a regular bonus scheme as well. So looking at payments, auditing what you pay, and making sure certainly for that basic holiday, we're paying normal remuneration. Some of you may be paying normal remuneration for basic plus additional plus contractual. Again, it's whatever your policy is on that. But the key takeaway is to look at what you are paying, and are you actually paying normal remuneration when you should be? One little heads up there, when you're looking at irregular workers and part-year workers, there isn't that distinction between basic and additional holiday when we talk about paying normal pay. So just something to bear in mind there. So yeah, some auditing is going to need to be done when we think about holiday pay. And again, if you're unsure, please do take advice. So I think that's going to be a useful one. Okay. So some holiday pay issues there to think about. And there's more holiday pay things that are coming in. Now, this is going to be particularly around our irregular workers and our part-year workers. Now, many of you who joined our case law update, our previous case law update, we were looking at the case of Harper Trust and Brazil, where a lot of us were scratching our heads and saying, hang on a minute, how can a part-year worker earn more holiday or be entitled to more holiday when they've only worked part of a year, whereas somebody who is part-time and works the full year, but their holiday is prorated? Didn't kind of make sense. And certainly there was government consultation on that, and now we have some new rules that are coming in now, just to say that they are coming in where your holiday year starts on or after the 1st of April. If your holiday year is January to December, then these changes are not going to be applicable to you until the 1st of January 2025. So what do we need to be thinking about, and what can we do here? Well, we're basically going back to the pre-Brazil position, thinking about accrual of holiday. So again, going back to what we had in the ACAS guidance there, looking at being able to accrue 12.07% of actual hours worked in your specific pay period. So again, helping businesses that have those casual workers, have those irregular workers and those part-year workers. There are also special rules around carryover of holiday, particularly, maternity, family-friendly, sickness, those other scenarios that I mentioned before. So again, we need to be looking at those, and the guidance is really helpful on that. So I'm saying, as I said, don't normally praise government guidance, but that's a really useful one. You are going to be able to roll up holiday pay, part-year and irregular workers, again, when these new rules become applicable to you. But just a word of caution just on rolling up holiday pay. Please, please, please make it clear on the pay slip, clear in your documentation with your worker as to the fact that you are paying basic rate of pay plus a rate for holiday, and make that very, very clear on the pay slip. So something to think about there if you are proposing to roll up holiday pay. And again, I've mentioned there about normal pay for EU and the additional amount of holiday. So what do we need to be doing? Well, we need to be looking at our holiday policies. We need to not just be looking at what we say we're going to do, but actually what we do in practice. So what does that look like? What are we actually paying? Do we need to go back and look at holiday pay? What are we including within normal remuneration? So having a think about that. Also making sure that your people are taking their holiday. And, we're kind of, a few months into most people's holiday years. We don't want people getting to kind of November, December and having a whole chunk of holiday that they need to take, because it's not great from their health, safety, well-being perspective, and also from a management perspective as well. So again, make sure your people are taking their holiday regularly throughout the holiday year is my advice. So again, some work there, I think, to be done. Many of you will be doing this already. We should have been doing this already. This is merely bringing into UK law those European case law decisions, which were already part and parcel of what we should be doing. And again, thank goodness we've got some clarification on the part-year and irregular workers, because I know particularly clients in the leisure and hospitality sector, education sectors as well, have been, scratching their heads about this. So some common sense resolution to that as well. Also, we saw from January some changes to the Equality Act, again, bringing in that European case law into UK law, particularly there around indirect associative discrimination. That was from a Romanian case, associative discrimination there, and that's now been brought into UK law. Just something to note there, there's been an addition to the definition of normal day-to-day activities. When we think about that definition of disability within the Equality Act, again, we're looking now not just at normal day-to-day activities, but someone's ability to participate in working life when compared with others. So I think there's going to be some interesting conversations there to be had, and maybe some case law coming through about what does participating fully and effectively in working life on an equal basis with other non-disabled workers. What does that actually mean, and what does that look like? So watch this space. Again, training, awareness for managers, particularly that legal training around the risks and responsibilities. What are the protected characteristics? What are the protected behaviours? Again, this is something that HR, you can be putting in place for your managers and your leaders. And again, if we can help with that, then please do let me know. Other changes that we saw in January, we saw changes to national insurance, didn't we? And also just to flag their changes to fines for right to work checks. So not just employment law, but again, we need to be thinking about immigration law as well. Do our managers know about the right to work checks? Do we know what those risks are? Do we know what the responsibilities are? So again, I think some information and awareness piece around those right to work checks and what does that look like. So again, some work there. So again, illegal fines, £45,000 per worker for the first breach and £60,000 for repeated breaches. So again, this is penalties that have teeth. So again, right to work changes. If you've got questions about business immigration, sponsorship licenses, getting people in on visas, or right to work checks, then please do get in touch because we've got a business immigration team who's ready there to help you. Particularly, obviously, we've got the April threshold changes coming in, which is going to put a lot of pressure at this time to get people through on those visas before the salary threshold changes. So again, if that's something that you're thinking about, something that's impacting your business and your recruitment, then please do get in touch because we're working with a lot of businesses who are wanting to get those people in now before the salary rate changes in April. Speaking of April, next month, goodness me, there are lots of changes that are going to happen around April. We know April is that month where things change. We're used to it, but this year we've got a lot of changes that are coming towards us very quickly. So it's about making sure that we are aware of them and we're up to date on what things we can be doing now to get ourselves prepped and ready. Firstly, as we know, national minimum wage, national living wage changes as it does sort of year on year. Just one thing to note here, obviously the national living wage is now applicable for individuals who are 21 and above. Again, was 25, has now come down to 21. So again, making sure that we've got the people that should be on the national minimum wage and the national living wage, making sure that we've got that correct. So again, making sure that we've got those changes. If we're speaking to payroll, we've got changes there to family leave. So the statutory minimum rates of pay there, that goes up again. It does every April. That will be applicable for those individuals who are on statutory maternity pay, statutory adoption pay, parental bereavement, statutory parental bereavement pay, paternity pay, and obviously where you've got people who are sharing statutory pay as part of shared parental leave. So again, making sure that we've got those checks and balances in place, that we've got the changes and that people are getting paid the right amount of money when they should be. Statutory sick pay is going up as well. So again, some changes there to think about, making sure that we've got information, again, of the right terms of pay. So making sure we've got that. And I think, there's going to be a lot of changes around protection for those on family leave. And the key one here is around redundancy protection. And what does that look like? And what does that mean? Okay, when we talk about redundancy protection, this isn't to say that somebody on family leave cannot be made redundant. What the current law protects is for those individuals who are on adoption leave, shared parental leave, and maternity leave, that if they are selected as at risk of redundancy, then they rank higher than others within that at-risk pool when it comes to being able to apply for or offered suitable alternative employment. So it's really the consultation process and the protections around suitable alternative employment that the current law protects. Now, from 6th of April, that is going to change. It's still going to protect those individuals on maternity, adoption, and shared parental leave. But what it will do, it's going to extend that protection to women who are pregnant. So at the point that your female staff member tells you that they are pregnant, then they are going to be protected. If their role is placed at risk, they're going to be protected in that pool if there is suitable alternative work. We are then going to see additional protection for those individuals who are then on maternity leave, adoption leave, and shared parental leave. Just to say, the protection for individuals on shared parental leave is where an individual has taken shared parental leave for 6 weeks, so a block of 6 weeks, and also they haven't taken maternity and adoption leave. So if you've taken maternity and adoption leave, you get the protection under that leave. If you've only got an employee who's taken shared parental leave, so maybe they're the partner, they will get protection only if they've taken a 6-week block, a continuous block of leave and a shared parental leave, remembering that you can take your leave discontinuously, so odd weeks, odd months, or you can take your leave as a block. You need to have taken your block of leave for 6 weeks to get that protection. And then what we're going to see is that protection extending for 6 months when somebody returns from their leave. So, you could get a situation where you've got people being protected if they're on adoption leave for 18 months. So it's going to be something we need to think about. It's going to be something that we need to be aware of. And I think making sure that managers particularly are aware of what those changes are, not forgetting our individuals who are on family leave, for consultation purposes, for suitable alternative employment options, but, making sure that we are factoring this within our redundancy consultation exercise processes. So making sure we've got that inbuilt within our processes, that we're not just offering that work to people who are currently on leave, but also there is that protected period when people return. Now, the rationale for that is as one can probably imagine, it would be a situation where somebody would be protected whilst they're on maternity leave, they return to work, and then they are selected for redundancy. So it's about making sure that we've got those protections and we're remembering that it's not just while somebody is either pregnant or away, there is also that extended protection when they come back. So again, just focusing on those changes there because it is important. When I started practicing law many years ago, the statutory maximum award for unfair dismissal was around about £11,000. From April, for dismissals that occur on or after the 6th of April, that's going up to £115,000 or 12 months gross salary, whichever is the lower. So that's a huge increase over the 20 years that I've been practicing law. So we need to bear that in mind. Again, these are the changes that are occurring for dismissals on or after the 6th of April of this year. Also, a week's pay is not just applicable when we think about the basic award and unfair dismissal, but also when we think about redundancy as well. So we use the statutory cap of a week's pay when we're working out statutory redundancy payments. So if an employee is entitled there to statutory redundancy, then again, from that date in April, we're going to be looking at £700 per week. So just some things to factor in there that we'll need to be aware of when we're going through those processes and when we're doing our calculations, working out potential costs, etc. So that's going to be something we need to think about. So flexible working, that's another change that is coming in for applications that are made from the 6th of April. So not applications that are currently going through. And remember, this is the statutory right to request to work flexibly. It's not the right to work flexibly, it's a statutory request. It's a statutory request to work flexibly in terms of your hours, your days, or from home. So what's changing and what can we expect? Well, key changes are that currently you have to have 26 weeks continuous service as an employee, what is going to change is that it's going to become a day one right. So employees are not going to have to try the job for 26 weeks before making a request. They can make a request as soon as they start with you. So what's that going to mean? Well, it's going to mean we need to think a lot closer about flexible working, what it means, can we accommodate? And we're going to have to do that from, I would say, those initial discussions around recruitment. So when your manager says, I need somebody, okay, what's the job description? What's the person specification? What does the job look like? It's full-time. Well, is it really? You know, we're going to have to think very carefully and seriously about making a job offering flexible working as a right there. So thinking about it more closely. We're also going to see that the time period, so from application being received until final decision, which ACAS code will say will be your appeal. So from, you know, end to end, receipt to final decision on appeal, you're going to now have 2 months in which to make that process work. So rather than the 3 that we see currently. So we're going to have to start getting ourselves up to speed, get managers aware, think about our processes, how this is all going to work. At the moment, individuals can make 1 request every 12 months. That's going to change, and individuals will be able to make 2 requests every 12 months. So that's going to be quite interesting, particularly if we have worked very, very hard to make a flexible working request work. And then, you know, a few months later, somebody makes a request to change again. Also, we are going to need to consult with employees. So this idea that we're going to have this open and transparent consultation process where we are going to weigh up the relative advantages and disadvantages of flexible working, that's now going to be enshrined. So, you know, we're going to have to be much more aware that we're going to have to have meetings with employees, do our investigation properly, as we should be doing anyway. But again, making sure that we've got those processes factored in and those discussions are meaningful. We are also going to see a new ACAS code as well. That has been published in draft. I can't really see that it's going to change, but again, it's worth having a look at. Applications still must be dealt with reasonably. And also another change is that currently employees have to put in their flexible working request, their statutory flexible working request, why they think the request would work and steps the employer can take to make it work. Again, employees are not now going to be required to basically do the employer's job for them. So again, just to think about how that works with our policies and our processes. So I think there's going to be some work to be done around flexible working. In fact, I ran a flexible working course for HR managers this morning where we looked at how this is going to work in practice. And a big thing for them was this communication piece with managers, how a manager is going to know they've got a flexible working request and making sure that we are within that 2-month limit. Yes, we can extend the time only if the employee agrees. So some changes there around flexible working. But I think we're going to have to make sure we get that. The whole process from requesting for appeal, yes. So a question here. So the 2 months is basically end to end. So from the date it is received to the date that you make your final decision, and if that is on appeal, the date of the appeal meeting. So again, we're going to have to make sure we've got that in order. Another question here, how can an employer justify that they decline a flexible working request? So the 8 grounds under the legislation that we currently have are not changing. So those 8 grounds are still going to be there. So looking at, you know, inability to recruit, impact on performance, impact on quality of work, impact on clients. So those 8 grounds are not changing. And I think that's quite interesting in itself, because I think a lot of the reasons where employers may wish to decline a flexible working request might be to do with things like teamwork, collaboration, supervision, mentoring, learning and development, those sorts of issues, which are incredibly important. But actually, how do you make those fit within the 8 statutory grounds, which talk about, you know, recruitment costs, costs to the team, client delivery? And if somebody has been working perhaps successfully full-time at home, and we're now saying to them, no, you can't work full-time at home because we need you to supervise, again, that I think is going to be quite challenging for organisations. So I think some work to be done there. I also think we're going to have to think very carefully, again, as we should be now, around, you know, evidence. We're going to need evidence to support the reasons for declining a request. Also remembering it's not just about flexible working requests, is it? We have to think about all those other legal risks: discrimination, disability discrimination, sex discrimination, you know, unfair dismissals, people resigning, people raising grievances. It's just about thinking more holistically about flexible working, and remembering this isn't about any agile working practices that you may have culturally in your organization. This is about people making flexible working requests individually. So for example, they want to you know, work part-time to suit childcare needs. It might be that they're looking to retire. So we've got a question here, some suggestions about why might people want to work flexibly. Childcare responsibilities is still the number one. I also think there's been a rise of people wanting to flex their working hours, particularly when they're perhaps looking to retire, perhaps if they've got caring responsibilities as well. So again, there are lots of reasons why people may want to work flexibly. But again, this is looking at that statutory right for an individual to request a permanent change to their contract of employment. So if you're interested in hearing more about flexible working, how that might look for your business, if you want to run some training for your managers, then again, please do get in touch. I can see I've got lots of questions about flexible working, so I think it's one of those areas that I think is going to become more challenging. So get in touch if we can help with that. We've got some changes as well happening to paternity leave. Again, a lot of the changes that we're seeing to flexible working, maybe to holiday as well, are really looking at, you know, people working in different ways, and people wanting to use use their rights, use their leave in different ways. And, you know, paternity leave is a prime example of that. So just, you know, a key change there, that what we see at the moment is that partners, fathers, are able to take that leave, 2 weeks of statutory leave, and they can take that as either a 1 week or a 2 week block within the first 56 days of birth or adoption. And what we're going to see now is that individuals can flex that leave. They can take 1 week, 2 weeks, 1 week, and then another week, and they can take that within the first year, so the first 12 months of birth and adoption. So again, a little bit of flex there as to when people can take it. Also some changes to notification provisions as well. And also if an employee wishes to change the date of their leave, again, a bit more flexibility in that within the changes. So again, expect those changes from the 6th of April as well. So we're going to have to look at, obviously it's quite a good time to sort of revisit our policies and processes anyway. Looking at our contracts, looking at our policies, what do we need to change? What do we need to update? So again, a really good time to actually be doing that. And we should be doing that anyway, HR. Every year we should be refreshing, we should be looking at particularly our contracts and making sure they're all up to date. Another new piece of legislation that's coming in is the carers leave. So carers leave is going to be a day one right for employees to be able to ask for up to 5 days leave per 12 months to care for an individual who has a long-term care need. Under the statutory rules, that leave is going to be unpaid. So again, perhaps an opportunity there for businesses to maybe look at their policies and processes. Is this something where maybe we could offer 5 days of paid leave? So again, maybe some opportunities there. But it will be where employees can request the leave. Employers, you will not be able to ask for evidence around, you know, why do you want the leave? Who's this person? Why, you know, what's their sickness? Why do you have to give them care? Obviously, there's a few data protection issues around that as well. So again, making sure that we've got some sort of, you know, process points around that. Who's the request going to be made to? Making sure we're keeping a record, so people are taking their 5 days leave within the 12 months, they're not going over that. But you know, I think it's one where I've seen a lot of individuals and a lot of businesses saying, actually, can we increase that? Can we make that better? Yeah, good point there. Is carers leave for 5 days prorated for part-time employees? Yes, it will be. So it will be prorated there. So that would be something to sort of say and factor that into your policies. Again, there will be some guidance on what, so there's things around, you know, what is a long-term condition. Yeah, and I think that's going to be quite difficult because, again, as an employer, it's not really for us to be doing that deep dive around, you know, why are you having the time off? What are you looking, you know, who are you caring for? What's their condition? And I suppose because the leave is unpaid, is there really going to be that much of an incentive for employees to want to take it anyway? So, you know, I think it's going to be one that's going to be difficult. Carers leave is unpaid, just there picking up there on a question that came up there around carers leave. So I think some sort of, you know, it's going to be one where we're going to have to wait and see what the detail looks like. And I'm sure there'll be some government guidance and ACAS guidance around what employers can and can't do in those situations. And it's going to be very interesting to see how many individuals are actually taking up the leave, particularly when it's unpaid. Neonatal leave, there was talk about neonatal leave coming in as a statutory right. So neonatal leave, so individuals being able to take up to 12 weeks of additional leave on top of their maternity, paternity, etc. That's not coming in at the moment, but obviously watch that space. And I have seen some businesses bringing that in as part of their suite of family benefits as well. So that, again, there are some opportunities there, aren't they? With all challenge comes opportunity. So let's move on to talk about what have we got coming up once we've sort of got our breath back from April. What could we possibly be looking at in the autumn? Well, for those of you that work in the leisure and hospitality sector, we've got some rules there coming in around tips. And how this is all going to work. So rules around the allocation of tips. We're going to have some ACAS guidance on this as well. But essentially, it's about looking at those service charges, really. So we're not looking at money, the cash that individuals leave in a tip jar or to an individual member of staff. This is looking at that money that is placed on the bill that the employer can control. So it's tips that the employer has control over. Now, many of you will already have a trunk system, but again, it's worth just having a look at that. Key things to think about is obviously the time. It has to be one where the tips have to be allocated fairly. Also, that tips are paid in a timely manner. So it's not like we're going to pay it every 6 months. So it really is, they have to be paid within a month of being paid or earned. So again, it's making sure that we've got those policies and processes in place, and also making sure that we are allocating tips fairly amongst staff. So what happens to the, you know, to the pot washer, to the front of house. So again, you know, are we fairly allocating tips between our staff? So again, we're going to have to look at ACAS code. It's going to be some training. We're going to need to look at our trunk system, and we're going to have to look at our processes more generally. So some changes there that are coming in with regards to tips. Another change to think about and what's going to be coming in is around TUPE. Now, TUPE, Transfer of Undertakings Protection of Employee Regulations, is really where you're looking at businesses where they are buying and selling, so disposing parts of the business. So not a share sale, although there could be an acquisition that does involve a TUPE transfer once businesses are sort of joined. But we're looking at where assets of a business are sold. So the actual parts of a business are sold, and there are employees attached to those working within those parts of the business. Can also be looking at second generation service provision changes as well. So TUPE there. A bit of common sense, I think, is coming in that will allow there to be consultation with employees directly. So at the moment, you either have to consult with an elected representative body or a body that you already have representing employees or with trade unions. So what's going to happen is that depending on either the size of the business that is being acquired or the number of employees that are transferring, you are going to be able to directly consult with affected employees, unless, of course, you do have a body or a trade union already in place. So again, hopefully there are some changes that will make the process simpler for employers, particularly where you've got those smaller 2P transfers. So again, direct communication in limited circumstances. But again, if you've got a trade union or an employee body that's already been established, you would need to continue to consult with them. This is going to be an interesting discussion, I think, for businesses to have, particularly when we are thinking about what training and what support do we give around sexual harassment. So sexual harassment is that specific protection within, the Equality Act. And the passage of this particular piece of legislation has been quite interesting, particularly of those who have followed it around the kind of free speech type issues and how can employers police speech of their customers, particularly, again, relevant people in the leisure and hospitality sector. But what we will see from the autumn, from October, is this duty to act reasonably. So what we're seeing is a shift from employers being reactive when it comes to allegations of sexual harassment to being proactive. So what are you doing as an organisation to stop this kind of behaviour carrying on? So what have you got? What are your policies? What are your processes? What is your training? Do you train managers specifically on what their risks are when it comes to sexual harassment? Do we take a proactive approach, or is it very much just don't raise it because we're not going to take it seriously? So again, what businesses can do proactively to support individuals in either making claims. Again, do we have confidential hotlines? Do we have, a dedicated person within the HR team that will be that if you like, that support for individuals who wish to raise concerns? But the key message is, if you're going to say we do all of this, you have to do it. So if you're going to say we take issues of sexual harassment very seriously and we want people to raise claims, that's brilliant. But if in reality you have a culture of silence and a culture where actually, yeah, that's so-and-so, well, we just tolerate that because they're our best salesperson. What are we actually doing? Not just to talk the talk, but what are we doing to walk the walk? And I think that whole kind of training and awareness piece is going to be really important. So again, something to focus on, and something where I think HR can have a really strong voice on this. So something to bear in mind for later on this year. But again, this is good stuff we should be doing now. Yeah, let's not wait until October. Let's really be looking at what do we do as an organisation, and can we really say that we take issues of harassment, and in particular sexual harassment, seriously as an organisation. Another change that's coming through, again, lots of law this year, is around the ability for individuals who have those irregular working patterns, and again, for those who have fixed-term contracts of less than a year, to be able to request from their employer basically more predictable working hours. So what can you give me that will make me be able to plan when I'm working, how I'm working, times, dates, etc. So it's going to be the right to request more regular working patterns, more predictable hours, as the legislation is termed. And again, it's a right to request. Like with flexible working, you will be able to refuse the request. There's only 6 grounds there to refuse rather than 8 that we see in flexible working, statutory flexible working requests. But again, there'll be an ACAS code of practice as well, looking at that, but really thinking about how we support those individuals who work on a 0 hours contract, who have that irregular working. Are they clear in terms of what their working patterns are going to be? So again, giving a voice there to support people who work differently within organisations. So that's something to have a think about. So it's going to be a busy year, and I think that there are some real opportunities there for HR to really have a strategic voice in terms of what these changes are, what they mean for your business, and also what you can do to support your managers and the business in driving forward change. I think personally, and just, you know, by the amount of questions that we've had today, I think certainly holiday and holiday pay, going back, looking at what you pay, how you pay it, what are your people earning? And is that regular? Do you have regular overtime, regular call out fees, you know, regular commission? What does the contract say? But not just that, what are people being paid within their pay packets? And what should that look like? So people aren't being penalised or discouraged from taking holiday. I think the changes to irregular and part-year workers, particularly going back, so we're just going to kind of forget that Brazil happened and go back to that 12.07% ability to calculate holiday pay, that ability to roll up holiday pay. I think that's going to be really useful, particularly where you do engage with casual workers, irregular workers. So again, there's some common sense with that. And I think, you know, the family friendly changes that we see coming through, I think there are some opportunities there for businesses to really get ahead of the curve and really look at where you can support your staff at different stages of the employee cycle, not just thinking about how can we support people who are on family leave, but also thinking about people who we want to keep, we want to retain within the business. You know, we don't want to be losing our key members of staff. You know, those individuals that have this huge wealth of knowledge, which is so valuable to an organization. We don't want to be losing them because they don't feel that 9 to 5, Monday to Friday supports them and where they are in their life journey. So Steph, I know we've had a lot of questions, but are there a couple that you just want to pick out?
Yeah, I will pick out just one, I think, because we're really running over time. So apologies, everyone, but thank you for joining and staying with us. Emma, that was really comprehensive. So flexible working was probably the most questions that we had. What do you think that HR could be doing now to get ahead and focus on that?
Yeah, I think really with flexible working, look, a lot of the things, you know, it's still there. People can still make flexible working requests. You know, the 8 statutory grounds aren't changing. We should be doing our evidence. We should be doing our investigation. We should be justifying our decisions if we're going to say no. I think really what we need to be doing is we need to be doing some policy stuff. So what do we need to do to update our contracts, update our policies if we need to? I think we need to be getting our managers on the ball. So some training would be super useful, particularly because that end-to-end date, you know, date of receipt to date of appeal is going to be tight. Yes, we can extend that time. You can ask for an extension, but again, the employee needs to agree to that. So again, I think we just need to do some work around how does a flexible working request work for our business. Another thing I would say about flexible working is don't assume that you can't make a flexible working request work. And also talk to your people. You know, if you've got somebody who's going off on maternity leave, have a conversation with them before they go. We're not holding anybody to anything. We're not guaranteeing that we can accommodate them. But, you know, if you can have conversations early, it will make the process much smoother, such that when somebody does arrive back, they don't say, oh, by the way, I now want to work, whatever it might be. And again, keep an open mind. If you can't offer somebody 4 days compressed and always taking a Friday off, if you could say we can offer you compressed days, but we might need to be flexible on your day off, again, think outside the box, because it costs a lot of money to recruit somebody. We don't want to end up in a dispute. Tribunals, etc., cost a lot of money. So again, trying to keep an open mind about flexible working.
And I think that's really interesting, because the number of people I speak to who are looking to change jobs because there's not the flexibility, and actually something that's really minute could be accommodated. So we all know how much it costs. And
sometimes it's temporary as well, isn't it? You know, people's lives
absolutely.
change. You might only need to work flexibly on a temporary basis, and then things would change. So, you know, yeah, that's interesting, isn't it? Yeah.
Absolutely. Yeah, I'm going to hold it there for the questions because we've had so many. So we will put together a Q&A fact sheet and we will make sure that you've all got access to that. We'll send it around within the next week, and as soon as that's been put together. But in the meantime, I just want to say thank you so much to Emma again for her overview today. It's been really comprehensive, and I'm sure a lot of you will find it really, really useful for takeaways and lots to think about for sure. And if you needed any legal advice, then obviously do reach out to Emma directly. And if you'd like to recruit, I'm here and happy to help as well. But in the meantime, we look forward to catching up with you in our next webinar, which will be in a few months' time. And have a lovely afternoon. Thanks so much for joining.
Thank you very much. Bye-bye.